I'd like to welcome everybody. Thanks for joining us for Law After Lunch, which is our lecture series we have every semester, and we are grateful that again this semester we can do this at least to a certain extent in cooperation with the Max Planck Institute here in Halle. And as in this semester first speaker, so to speak, from the Max Planck Institute, I'd like to welcome Christa Rautenbach from South Africa, from the Northwest University of a city which I will mispronounce now probably, Potchefstroom?
No, perfect.
Perfect? Oh,
perfect.
Okay. Which is a city about 120 kilometers from Johannesburg, a rather small town with, however, a rather comparatively big university, if I may say so, compared to the size of the city. It sounds like a very interesting place, and a place where research in the area of legal pluralism and comparative law is obviously taking place. Christa Rautenbach is a professor at the law school at that university. Her main fields of research and interest are legal pluralism, customary law, mixed jurisdictions, cultural diversity, law of succession, from, as we just discussed over lunch, more from a constitutional law perspective, if I may say, not that much from a private law perspective, but this differentiation between private and public law and so on is a very typical German way of thinking. In other legal orders we do not have it, which is, I think, a very good development, so to speak, not to have such strict boundaries between different ideas of approaches towards legal problems. Christa received her legal education at her now home university, and she has been a visiting scholar worldwide, more or less. Most famously, probably, she is an Humboldt Foundation alumni and was with the Humboldt Foundation at the University of Trier and the Max Planck Institute in Heidelberg. She almost was here for 5 months about at the Max Planck Institute. Her research stay in Halle ends at the end of the year. And of course we all hope that you will remember and have good memories on Halle and the Max Planck Institute, of course, but also the law school as far as you have a chance to get to know it today. Thanks again, all the students and PhD students and colleagues, for joining, and you have the floor. Thanks again for coming, please.
Thank you very much for the kind introduction. I have decided not to do a very complicated theoretical session today because I think it's no sense going into those heavy theoretical stuff when somebody doesn't know that much about the legal system anyway. So I will try and be as brief as possible and to give a wide outline of the theme that I'm addressing today. But before I do that, I was explaining during lunchtime where the name Potchefstroom comes from. When you hear it the first time, it's a difficult name to say, but when you break it up, it's actually a very easy word to say, because pot refers to a pot, and a chef refers to being the boss or being the president of a place, and stroom is the Afrikaans word, because my mother tongue is Afrikaans, for a little stream. So if you add it on, pot, chef, stroom, it's actually a very easy word to understand. So I'm just going to talk a little bit about the Northwest University. As Christian was saying, it is actually a huge university. It is the second largest university in South Africa. It has 3 campuses. The campus where I am, and that's also the building, the law faculties are usually in the eldest buildings all over the world, and we also got the eldest building at the university. We have 51,800 students at that campus, but only 21,800 live on the campus. The other students are what we call distance students. Then we have the Mafeking campus. They have 11,000 students, and most of them are resident students. And then we also have the Vaal Triangle campus with 7,700 students, and they're also mostly resident students. So we have a total of 73,400 students studying at this particular university, which makes it the second largest university. The first largest, or the one on top, is what we call UNISA. It is the University of South Africa, and that is a distance learning university. So you can actually say we are the largest residential university in the country. We're actually quite proud of that because we beat University of Pretoria, we beat University of Cape Town, and we also beat University of Stellenbosch, the three universities which we are always fighting against. So if you look at the map of South Africa, those three campuses are quite far from each other. We have the one in Mafeking on top. Then we have our university, the Potchefstroom campus, 200 kilometers away. And then we have the Vaal campus, which is 80 kilometers from Potchefstroom University and even further away from the Mafeking campus. So those three campuses, different geographical areas, we are one university, not as easily as here in Halle where all the campuses are walking distance from each other. So you can imagine that makes working together quite a challenge, but we have to do it. If you look at the number of students enrolled per race, and race remains a huge issue in South Africa. So we still have to give racial indications whatever we do. And I presume that will remain like that for a long time, because we have all these programs in place where we try to help those who were disadvantaged in the past. So African students, 51,000, and when we say African students, we actually mean black students. Colored students, 3,500, and that's an interesting phenomenon. I don't know if you know much about the history of South Africa, but we had racial classification before the 90s, and people were either classified as black, or colored, or Asian, or white. Those were the four main categories. And if you were of a mixed race between offspring of a white and a black person, you were referred to as colored. So that's where the word color comes from. It actually means mixed race. And so our policies, our segregation policies all revolved around this racial classification. And that is the reason why we still have those categorizations. So if you look at the numbers, you will see the university is quite transformed. My campus, Potchefstroom campus, is the one which have about, I would say, 35 to 40% black students. So our campus is mostly white. The Mafeking campus is mostly black students. I would say about 98% of those students are black students, and the Vaal campus is more 50-50 white and black. If you look at the statistics of the Faculty of Law, and this is only the Potchefstroom campus, we have also a law faculty at the Mafeking campus, and at the Vaal campus we don't have a law faculty, but they do teach a few law courses which is mostly service courses for other grades that they are studying there. We have 1,348 students at the law faculty, and we have added to that 140 LLM students, and we have about 65 doctorate students. It's a small faculty. We have only 37 members. We have 13 on the administrative staff. We also have a practical side, and that is the legal clinic, which provides free legal services to the poorer communities. We're also very proud of the Potterstroom Electronic Law Journal that we have. It started in 1998. It is the first electronic law journal, fully peer-reviewed, and it was open access from day one. So it is our community service. I'm also the chief editor of this particular journal, and we are quite proud of it because it's been booming. Where is the receiver of this? Because it doesn't want to...
It's here.
So I must point in that direction. For example, last year we published 91 articles with a total of 2,828 pages. So you can imagine how much work that takes to publish so much. We started off with only an editor-in-chief and an executive editor doing all the work, which was me, of course. And now we have 5 edition editors, what we call them, and 1 editor-in-chief, and we also have an assistant helping a little bit with the administrative work. So coming to what I wanted to discuss today is, of course, you can think for yourself that when you have a legal system where more than one legal system apply, there's always a fight between those 2 legal systems. The one feels that it doesn't get enough attention, or that the other one is overruling it, and you never know which system to apply. So over the years, there have been certain developments which made me wonder, can you say that we are now mixing our common law and the customary law, and what those 2 legal systems mean, I will explain to you in a moment. So my question is, are we blurring the lines between the 2 legal systems, or are we making a unique South African law? Just look at our diverse population. We have more or less 55 million people in South Africa. 18% of them are black people. About 37 million of those people still live in rural areas under a system of customary law. So that is quite a lot of people. And again, we have about 9% colored, the mixed race that I was referring to. We have about 9% European, which they call white, and we have about 2% Asian. I'm always using myself as an example. I think of myself as African, but people look at my color, skin color, and they say, no, you're white. So you must be European, you must be a visitor in Africa. So I decided, well, let's put the minds at ease, and I sent my DNA into this genographic project that they've got. And my results came back, and guess where I'm coming from? West Africa. So now I have this certificate to show that I'm indigenous to Africa, so if anybody wants to argue with me, I'll just get my certificate and show them. The other complication in South Africa is, of course, official languages. And when I say official languages, it really means official languages. It's not we recognize all those languages. Those are the official languages. The most spoken mother tongue is Zulu, 24%, Xhosa, 18%, and Afrikaans, my mother tongue, 13%. And then Sotho, and only then English follows. So you can see that Afrikaans, which is incidentally also an indigenous language because it is a language that developed in South Africa. So our claim to fame is also that Afrikaans is an indigenous language. So that means we have a mixed legal system. And I refer to it as potfood, boikikos in Afrikaans. Because potfood is made of, you start with the meat at the bottom, and meat is the constitution. And then follow all the different layers of all the laws, other laws. And when you boil this potfood, and it's really a very South African food, when you boil it, the flavor of that meat goes to all the other layers. And that is exactly what our constitution do. Our constitution is this meat that flavors through all the laws. So when I talk about customary law, it's been influenced by the Constitution. And when I talk about the common law, it's been influenced by the Constitution. You cannot get away from that. So when you talk about our Western mix of laws, it is the Roman Dutch law. 1652, Jan van Riebeeck from the Dutch, with the province of Holland. The law at that moment at the province of Holland was the Roman Dutch law before the Dutch codified the laws of all the different provinces. Then the English came, 1795. They relinquished South Africa back to the Dutch for a few years, and from 1806 they were in South Africa permanently. And they took a decision that they're not going to replace the Roman Dutch law in South Africa. It's going to remain the law of the land, but of course English influence started, especially in those public institutions and the commercial law. There's a lot of influence of English law. So we had this mix already. We have an uncodified legal system consisting of Roman Dutch law influenced by English law and also adapted and changed by means of legislation, and we follow the rule of precedent as well. So we also have court cases which make the law as they go along. It must be extremely confusing to somebody else coming from the outside that is used to a codified system to see how this works. And a lot of debates I know in international law is about the fact that they think the common law and the civil law cannot be used together. But the South African legal system is a perfect example of where the civil law and the common law has been working very well together. And so if I use the word common law of South Africa, I'm not referring to the English common law. I'm referring to the law common to South Africa. So just don't let yourself be confused by that. That law applies to everyone in South Africa. But then we also have what we call the customary law. And that is an umbrella term for all the different laws of the indigenous communities in South Africa. There is, by the way, a debate going on whether Africans are indeed indigenous to South Africa or not. Because when the Dutch came in the Cape, it was only the Khoi and the San people that they saw or that they found down in the Cape. There were never any Africans when colonialism started. And as the English and the Dutch started to fight about things, the Dutch moved to the north. That is when the Groot Trek were that history books are talking about. So they moved to the north, and then they came into contact with the other African communities that were moving south. And then, of course, the big fight started between white and black in the inland of South Africa. Now, those legal systems are mostly oral tradition. It's not written down. There is a little bit of codifying that went on by means of legislation, and of course you also get court cases which give those laws. So you have this whole debate there about living law and official customary law going on in the courts and also in the literature. So that is what we call our state law pluralism. Now, the relationship between these two systems have always been a little bit uneasy, and the common law has often been accused of being a bad boy picking on the customary law. Now, since the enactment of the two constitutions, first the interim constitution in 1993 and then our final constitution in 1996, these two systems have been placed on an equal footing. And so customary law and the common law are exactly in par with each other. It's only the constitution that we need to look at. So the relationship between the two have been improving, although you still get a lot of literature still complaining about the common law not being fair. Now, I'm just going to do two examples to show you how the relationship has improved. The first one is the fusion of values between the common law and the customary law. And you probably heard about Ubuntu. Now, just to show you that even though everybody's writing that these debates are new debates, there was already written in a Lesotho law journal. And I don't know if you know where Lesotho is, but Lesotho is a little island of a country in the middle of South Africa. Just a little spot, looks like Luxembourg in Europe, for example. Nothing around it but South Africa. Justice Mohammed wrote, Southern Africa will be poorer without the sound discipline, effectiveness and historical experience of Roman Dutch law, and will also be poorer without the spiritualizing, humanistic and bonding values of customary law. So already in 1985, he recognized that Roman Dutch law could really do better if certain customary law values were taken into consideration, but I'm sure he didn't have Ubuntu in mind. So what eventually happened is, in the interim constitution, the 1993 constitution, in the English version of the constitution, it included Ubuntu, to take the value of Ubuntu into consideration. And that word Ubuntu, it's a Zulu word, were translated into the Afrikaans text of the Constitution, and that was the Constitution that was signed as human dignity. So immediately the judges saw this gap and started to use the word Ubuntu instead of using human dignity, because they thought this is actually a nice way of getting a customary value into our legal system. And the first judge to speak about it was Justice Mokgoro. She also was a law lecturer at the Mafeking campus. So it's one of our export products that we are very proud of. Now, what is Ubuntu? Ubuntu is a customary law value. It is an equity principle which plays a major role in the reasoning of the South African judiciary, both in common law and customary law issues. So it was definitely one customary law principle that was taken into the common law. The judiciary elevated this Ubuntu principle, which is actually a social value. They elevated it to a judicial value. And that's the judge I was referring to. She has retired in the meantime. She's not a judge of the Constitutional Court anymore. But she wrote, and we are very proud of this article because it was one of the articles that was written in 1998 in sort of the founding edition of the Electronic Law Journal, and it's been cited quite a lot in the international literature, where she said it is a founding principle of law. It holds the potential of reshaping South African jurisprudence in general and customary law in particular. It coincides with the founding values of the Constitution set out in the Section 1 of the Constitution, and that was still the 1993 Constitution, but it's also taken up in the final one: human dignity, equality, promotion of human rights and freedoms, and multi-party democracy. Now, if you look at those values, I mean, that is exactly the values that were complicated during those years just after apartheid. So that is why they were repeated in the Constitution. And the case where it was brought into the realm of the law in general was, of course, S versus Makwanyane. It is the case that dealt with the death penalty in South Africa, and it was the case that declared the death penalty unconstitutional in South Africa, where Justice Mokgoro said Ubuntu translates as humaneness. In its most fundamental sense, it translates as personhood and morality. Metaphorically, it expresses itself in umuntu, ngumuntu, ngabantu. A person is a person by or through other people. So that is, this communitarian value is something which is very important in the African families. So that's been taken into the South African legal sphere by this case. And as she said there, while it involves the key values of group solidarity, compassion, respect, human dignity, conformity to basic norms, and collective unity, in its fundamental sense, it denotes humanity and morality. Now, that is values that we know. I mean, it's Western names, it's things that we all strive to, but what the court did is to take it from the customary law, to take a name, a word from the customary law and say, this is what we should do. So we can debate about this, but is it really customary or is it not customary? But do you get it all over the world? Is it values that we should all strive for? But the fact that she brought it into it just shows that the South African judiciary is serious when it says that they're going to work with customary values as well. So even if it's only for that reason, it is quite laudable. Now, in the meantime, also the legislature has decided that it's going to include Ubuntu values in some of its legislation, and one example is the Child Justice Act, which says, for example, in Section 2B, one of the aims of the Act is to promote the spirit of Ubuntu in the child justice system. Now, it doesn't say, of course, what it means with Ubuntu, so we have to go out and see what the courts are saying about it, what the literature is saying about it, to exactly see what Ubuntu means. And I think in this context, it's mostly human dignity, that particular value. So it's just an example to show where it's been incorporated. The second example that I would like to talk about is the fusion of laws, where those two systems have been fused. And I'm using the customary law of succession as an example. And again, I found this quote already written in 1990 by Justice Albie Sachs. He was also one of the Constitutional Court judges. In his book, Protecting Human Rights in a New South Africa, and that was before the interim constitution was enacted. He said, Roman Dutch law will survive in future by fusing itself with African law, meaning customary law, shedding its name and becoming an integral part of a new South African law. So already then he was predicting that we are going to develop a new South African law where both those legal systems are being used. So just to be a quick recap, our succession laws before 2005, we had the common law of succession, European roots, and there we have the Intestate Succession Act that deals with interstate matters where you don't have a will. We have Roman Dutch law rules, of course, and we have the freedom of testation in terms of the Wills Act, and this applies to everyone, irrespective of where you are, except those subject to customary law. The customary law of succession, African roots, we had there Section 23 of the Black Administration Act, which is a very controversial act. It's been repealed almost entirely, but there are two provisions still operable. Those two deals with traditional courts, civil jurisdiction and criminal jurisdiction. So it's still not entirely repealed. We have the customary law rules, so that would be your unwritten rules that you need to go and find applicable to a particular community. There's not unrestricted freedom of testation because people were compelled in terms of Section 23 to devolve certain property in terms of customary laws. So they couldn't bequeath that by means of a will. Section 23 had to be followed. So what happened then is that Section 1(4)(b) of the Intestate Succession Act said you cannot apply that to a customary law estate. So there were definitely, in terms of the common law, it could not be applied. In terms of the customary law, certain rules had to be applied. So there were no unlimited freedom of testation, similar to what we have in the common law. That was then attacked in 2005. In the one case in the Constitutional Court, the Bear case, it's a very well-known case in South Africa. So if you ever want to read something interesting, read this particular case. It declared Section 23 of the Black Administration Act unconstitutional. So it means then, what are we going to put in that place? And they were looking at the rule of male primogeniture, where the eldest son inherits. And they said, well, this is unconstitutional because it's of inequality. Women and other sons are not treated equally. And that is why we're declaring it unconstitutional. We cannot develop this rule because we don't know what the customary rules are of all the different traditional communities. So what are we going to do? We think replace it with the Intestate Succession Act, which is a common law act. And from now on, that will apply to everybody. This case was followed by a piece of legislation, the Reform of Customary Law Succession Act, and that was to give effect to this particular case. And this act must now, when it deals with the customary law estate, take into consideration the Intestate Succession Act plus this particular act. Now what this act did was to incorporate living customary law in the act. And we all know what descendant mean. What does descendant mean? Any one of you?
Son.
A son? A daughter? A granddaughter, a grandchild? What is the link? Blood. And this act said, we're going to expand the word descendant to mean more than blood, because in customary law, everybody that you look after is also regarded as children. So we're going to change the definition of descendant so that in the case of customary law estates, a descendant will also be regarded as somebody that you look after. The second word that the case, but that's only for customary families, remember, so they apply the Intestate Succession Act, read with this particular act, so there are special circumstances when it's a customary law estate. The other definition that they change is the one that says spouse. Now, who do you think of when you think about spouse? A wife or a husband, or maybe same-sex partners as well, but it is somebody that you are married with. And here we have certain situations in customary law. The first one is called substitute wife. So you would marry your wife. If she cannot bear any children, you would substitute her with somebody else, but you won't divorce your wife, just to bear children, so that you can have children. That child is then regarded as a child of this man and woman. So they said, okay, we must make provision for that as well. So they changed the definition of spouse in the case of customary law estates to make provision for that as well. And the other one is women-to-women marriages. In customary law, there is a situation where a woman can bear any children, and she would marry another wife who is able to bear children. It will not be a sexual relationship. It's just for children-bearing sake, that she is then the wife of that other woman, and all the children that she bears, she will go out and get a man just to make her pregnant. It's almost like surrogacy. And that child will then be regarded as. So the Act had to make provision for those special circumstances as well. So it gave a definition of spouse and said, okay, and it includes all these other categories of people as well. So if it's a customary law estate, those wives will then also be regarded as spouses. So they must be treated the same if it is the Intestate Law of Succession. So the Reform of Customary Law Succession Act says the estate or part of the estate of any person who is subject to customary law must devolve in accordance with the law of intestate succession as regulated by the Intestate Succession Act. So this is actually a replacement of the customary law of succession with common law, but making provision for those special circumstances. And then it changed the meaning of descendant to include also somebody who's accepted by the deceased as a child in accordance with the customary law. Seed-raising women and women involved in women-to-women marriages was also included as descendants. I'm not going to bore you with this particular thing. I wrote a whole article about that because they regarded as descendants, but they're also regarded as wives, and we have certain rules how to devolve an estate between descendants and between spouses. So what actually happens if you interpret the act literally, it means that they get a double portion because they should get it as descendants and they should get it as spouses. But the master is not interpreting it this way, and it interprets it in context, which is actually incorrect, but they haven't changed it yet. And then, of course, definition of spouses, seed-raising wives, and also women included to women marriages. So my question is, did this mix of customary and common law of succession erase the duality of the laws only in the case of succession? And is this new mix something that can be viewed as South African law described by Albie Sachs in that earlier quote? If we compare the two, on the left-hand side is the common law situation, on the right-hand side is the African customary law situation. You will see that we have the same act that applies to both the situation. So it will mean that Roman Dutch law legal principles are going to apply, and it applies to everybody subject to customary law. And freedom of gestation are now exactly the same in the two legal systems. So I would say, yes, I think so. Oh, I'm going back now, sorry. But, and this is where legal anthropologists becomes important. This is what the law says. The fact is, actually, in South Africa, it seems that those incorporation of the two legal systems is mere paper law. If you go to the rural communities, and this is research that a colleague of mine has done, she's a legal anthropologist at University of Cape Town, it appears that it doesn't work like the legislature and the courts have thought it is going to work. Because she went into the communities where there are still communal land. And communal land, I don't know if you know much about it, but it belongs to the chief of that particular area. And the chief allocates the property to individuals in that community. They don't get any title to it. So the day they die, there is no property as we know it as a Western concept that falls into the deceased estate, which must then be devolved to family members. So that's the one problem. And then the master's office, and that's the lady sitting below, who has to devolve the estate, because that must all be done under the supervision of a master, cannot devolve that estate to the family members because she doesn't have a title deed. So as a government official, she needs a title deed to do the distribution, and she cannot do it. So the property is being dealt with in this community, and nothing is ever on paper. So there's no guarantees that the persons who is entitled to this property as beneficiaries of the deceased is ever going to get it. The chief can take that property back, allocate it to somebody else, and it indeed creates a problem on a practical level. So that is it is my contention that officially those two legal systems have merged in the case of the law of succession, but on an empirical level, unofficial level, deep legal pluralism, it is definitely not changed at all. It is business as usual. So I think the divide between our official legal pluralism system and our unofficial legal pluralist system is definitely dividing. So officially, I think it has merged in this particular case example, but unofficially, I think it's business as usual, and there has been no merger of the two legal systems. Customary law continues in the background as it always used to, and it's going further and further away from its common law partner. That is my story.